Dear all, today I am going to start with the Bare Act of Companies Act 2013. And with the Bare Act, I will be touching upon the relevant rules also of the same. To start with, we are going to take up Chapter 11, Appointment and Qualifications of Directors. Hope the series of the Audio Bare Act will be useful to one and all. Chapter 11, Appointment and Qualification of Directors. The section starts from section 149 and it goes up to section 172. So let's take up the first section, that is section 149, Company to have Board of Directors. Section 149, Company to have Board of Directors. Subsection 1 of section 149. Every company shall have a board of directors consisting of individuals as directors and shall have a minimum number of 3 directors in case of a public company, 2 directors in case of a private company, and 1 director in case of a one-person company, and b. a maximum of 15 directors. Provided that a company may appoint more than 15 directors after passing a special resolution. Provided further that such class or classes of companies as may be prescribed shall have at least 1 woman director. Here in case of woman director, we have to refer Rule 3 of the Company's Appointment and Qualification of Directors, Rules 2014. Let us see what it says. Rule 3. Woman Director on the Board. The following class of companies shall appoint at least 1 woman director. Every listed company, every other public company having paid up share capital of 100 crore rupees or more or turnover of 300 crore rupees or more. Provided that a company which has been incorporated under the Act and is covered under the provisions of the second proviso to subsection 1 of section 149 shall comply with such provisions within a period of 6 months from the date of its incorporation. Provided further that any intermittent vacancy of a woman director shall be filled up by the board at the earliest but not later than immediate next board meeting or 3 months from the date of such vacancy, whichever is later. Explanation. For the purposes of this rule, it is hereby clarified that the paid-up share capital or turnover, as the case may be, as on the last date of latest audited financial statements shall be taken into account. Subsection 2 of section 149. Every company existing on or before the date of commencement of this Act shall within 1 year from such commencement comply with the requirements of the provisions of subsection 1. Subsection 3 of section 149. Every company shall have at least 1 director who stays in India for a total period of not less than 182 days during the financial year. Provided that in case of a newly incorporated company, the requirements under this subsection shall apply proportionately at the end of the financial year in which it is incorporated. Here we have to see a notification which says that non-compliance of minimum residency in India for a period of at least 182 days by at least 1 director of every company shall not be treated as a non-compliance for the financial year 2021. Okay, this was a circular dated 2010-2010. There is another circular which says non-compliance of minimum residency in India for a period of at least 182 days by at least 1 director of every company shall not be treated as non-compliance for the financial year 2019-20 also. That is a relaxation circular dated 24th March 2020. Subsection 4 of section 149. Every listed public company shall have at least 1/3 of the total number of directors as independent directors, and the central government may prescribe the minimum number of independent directors in case of any class or classes of public companies. Explanation. For the purposes of this subsection, any fraction contained in such 1/3 number shall be rounded off as 1. Under the subsection 4, we have to refer Rule 4 of the Company's Appointment and Qualification of Directors, Rules 2014. Let us look what it says. Rule 4 of Company's Appointment and Qualification of Directors, Rules 2014 deals with number of independent directors. Subrule 1 says, the following class or classes of companies shall have at least 2 directors as independent directors. The public companies having paid up share capital of 10 crore rupees or more, or the public companies having turnover of 100 crore rupees or more, or the public companies which have in aggregate outstanding loans, debentures and deposits exceeding 50 crore rupees. Provided that in case a company covered under this rule is required to appoint a higher number of independent directors due to composition of its audit committee, such higher number of independent directors shall be applicable to it. Provided further that any intermittent vacancy of an independent director shall be filled up by the board at the earliest but not later than the immediate next board meeting or 3 months from the date of such vacancy, whichever is later. Provided also that where a company ceases to fulfill any of the 3 conditions laid down in Subrule 1 for 3 consecutive years, it shall not be required to comply with these provisions until such time as it meets any of such conditions. Explanation. For the purposes of this rule, it is hereby clarified that the paid up share capital or turnover or outstanding loans, debentures and deposits as the case may be, as existing on the last date of latest audited financial statements shall be taken into account. Provided that a company belonging to any class of companies for which a higher number of independent directors has been specified in the law for the time being in force shall comply with the requirements specified in such law. Subrule 2 says, the following classes of unlisted public company shall not be covered under Subrule 1, namely A joint venture, B, a wholly owned subsidiary, and C, a dormant company as defined under Section 455 of the Act. Subsection 5 of Section 149 says, every company existing on or before the date of commencement of this Act shall, within 1 year from such commencement or from the date of notification of the rules in this regard as may be applicable, comply with the requirements of the provisions of Subsection 4.